Just 11 days ahead of what many consider one of the most important legal showdowns in modern motorsports history, NASCAR made an unexpected and aggressive move. The sanctioning body submitted a court filing seeking to keep 2 of 23XI Racing's 3 owners out of the courtroom during the upcoming trial. This twist landed on November 20th, 2025, less than 2 weeks before the December 1st trial date in Charlotte, North Carolina. U.S. District Judge Kenneth Bell responded by issuing a formal order that acknowledged NASCAR's request and outlined the next steps in the process. According to reporting by Matt Weaver of Motorsport, Judge Bell explained during a pretrial hearing that the defendants wanted 2 of the team's owners excluded under Federal Rule of Evidence 615, which deals with the removal of witnesses from the courtroom. The judge said the matter was still under deliberation and allowed each side to submit a written brief of no more than 5 pages by noon on November 25, 2025. No rebuttal briefs, responses, or counter-arguments would be allowed after that deadline. 23XI Racing is owned by Michael Jordan, Denny Hamlin, and Curtis Polk. NASCAR's request would prevent 2 of the 3 from attending the trial in person. The filing relies on Rule 615, which instructs courts to exclude witnesses to prevent them from hearing the testimony of others. However, the rule also includes several critical exceptions. It does not permit the removal of a natural party in the case. An official representative designated by counsel, someone whose presence is vital to the legal arguments, or anyone who is legally entitled to be there. That means the judge must determine whether the owners qualify under one of these protected categories or whether NASCAR's request can move forward as stated. The lawsuit itself dates back to October 2, 2024, when 23XI Racing and Front Row Motorsports jointly filed an antitrust complaint against NASCAR and Chairman Jim France in federal court in Charlotte. The 2 organizations claim NASCAR has violated antitrust laws through the way it structures, controls, and enforces the Cup Series charter system. Out of the 15 Cup Series teams holding the 36 charters, 23XI and Front Row were the only ones who refused to sign the updated charter agreement in August 2024. A jury of 9 people will spend roughly 2.5 weeks hearing testimony before determining whether NASCAR crossed the legal threshold under Section 2 of the Sherman Antitrust Act. At the center of this case is the charter system NASCAR introduced in 2016. Charters give teams guaranteed entry into all Cup Series events and provide a dependable share of purse and revenue distributions. The plaintiffs argue that NASCAR tied the 2025 charter renewal to a mandatory waiver of all current and future antitrust claims. According to them, teams were told they had to sign away their legal rights if they wanted to compete in the 2025 season. Discussions about the new charter structure began back in 2022, but after 2 years of slow-moving negotiations, NASCAR delivered a final take-it-or-leave-it agreement. Teams were forced to sign by September 6th, only 2 days before the start of the 2024 playoffs at Atlanta Motor Speedway. Sources speaking anonymously to the Associated Press said teams felt heavy pressure from NASCAR and believed they were being boxed into a corner. One of the key reasons 23XI and Front Row declined to sign was NASCAR's refusal to make charters permanent assets. Matters escalated further on August 28, 2025, when a hearing regarding a potential injunction revealed a series of private text messages between executives at NASCAR and 23XI Racing. After the hearing concluded, attorney Jeffrey Kessler stood alongside Michael Jordan and Denny Hamlin as all 3 addressed the media. Jordan said, "If I have to fight this all the way for the betterment of the sport, I will." The revealed text messages underline the tension between the 2 sides. NASCAR presented one message from Hamlin to what appeared to be his business partners reading, "I'm in for the fight with NASCAR. My resentment for the France family runs deep." Another message from Jordan to Curtis Polk added, "I think people understand why we're doing this. Something positive will come out of this. Teams are going to regret not backing us." The conflict intensified over the summer when the U.S. Court of Appeals for the Fourth Circuit reversed a preliminary injunction, ruling on June 5, 2025. When a request for a rehearing was denied, 2311 Racing and Front Row Motorsports were forced to compete as open entries beginning in July at Dover Motor Speedway. That change stripped the team's 6 cars of guaranteed starting spots and drastically cut their purse winnings. If more than 40 cars showed up to qualify, the team's entries were no longer assured a position on the starting grid, putting them at a significant operational disadvantage. Another major shift came on October 28, 2025, when Judge Bell dismissed NASCAR's counterclaim, accusing 2311 Front Row and co-owner Curtis Polk of conspiring with other organizations to gain leverage in the 2025-31 charter negotiations. Bell ruled that group bargaining was reasonable under the circumstances, especially since NASCAR's one-on-one discussions with individual teams resulted in revisions to the agreement, and because all teams ultimately received identical charter contracts. Then on November 4, 2025, Judge Bell issued a significant partial summary judgment ruling. He declared that the relevant market in the case is premier stock car racing and that NASCAR holds dominant power in that market. The ruling eliminated NASCAR's argument that teams could simply race somewhere else, such as in other domestic or international series. Bell concluded NASCAR effectively controls 100% of the premier stock car market and holds monopsony power. The trial will now focus solely on whether NASCAR used that power unlawfully to suppress competition at the top level of the sport. That ruling was followed by another development on November 6, 2025, when the teams dropped their Section 1 Sherman Act claim. Section 1 deals with agreements that restrain trade. The remaining claim, Section 2, concerns monopolization or attempts to monopolize. 2311 and Front Row now argue that the 2025 charter agreement and its revenue distribution model prevent them from operating a financially viable racing team. They assert NASCAR exerts near-complete control over their business structure. It owns most of the Cup Series tracks, dictates costs through mandated single-source suppliers for next-gen parts, and leaves no room for a competing league or sanctioning body to emerge. NASCAR, on the other hand, maintains that it has built its position legally and cites increased charter payouts in the 2025-31 agreement as evidence that its system benefits teams. NASCAR claims it became the leading motorsport in America through decades of investment, innovation, and commitment to the sport. Financial documents released on October 29, 2025, revealed NASCAR posted more than $537 million in comprehensive net income in 2023, boosted significantly by a major land sale, and earned $13 million in 2024. Commissioner Steve Phelps emphasized that NASCAR's balance sheet shows more than $1.2 billion in invested capital, and that most profits are reinvested into the sport, its teams, and its workforce. On November 22, 2025, the unsealing of additional court exhibits uncovered text messages from 2022 and 2023 showing NASCAR executives discussing concerns over the SRX series and expressing frustration toward longtime team owner Richard Childress after he criticized NASCAR publicly. Front Row Motorsports' financial disclosures were also made public, revealing the team has lost more than $100 million over its lifespan in NASCAR. That information could strengthen their argument that the current charter revenue split is not sustainable. The revenue structure ties directly into the $7.7 billion media rights deal that begins with the 2025 season. Judge Bell has not hidden his skepticism about the long-term outcome. During a settlement conference, he told both sides, "It's hard to picture a winner if this goes all the way to the end." Multiple attempts to settle the case before trial failed, as both teams and NASCAR remain firmly entrenched in their positions. Several settlement sessions supervised by Judge Bell and mediator Jeffrey Mishkin stretched across multiple days in October 2025 and required all major stakeholders to participate. NASCAR was represented by Jim France, Lisa France Kennedy, Ben Kennedy, Commissioner Steve Phelps, and President Steve O'Donnell. On the team side, 2311 Racing co-owners Michael Jordan, Denny Hamlin, and Curtis Polk were joined by Front Row Motorsports owner Bob Jenkins. The court is expected to rule on NASCAR's request to exclude 2 of 2311's owners after reviewing the submitted briefs, which are due by noon on November 25, 2025. Once that decision is made, both sides will move into the final stretch. The trial officially begins on December 1, 2025, in Charlotte, North Carolina.